Hello again. In the week 1 video, What is Administrative Law?, I talked briefly about the growth of the administrative state. In this video, I am going to talk about that in a little bit more detail, and I am going to look at some of the reasons for this apparently inexorable growth of the administrative state, as well as the responses of the law to it. I want to start by talking about a famous article by the historian Oliver MacDonagh called The 19th Century Revolution in Government, a Reappraisal. It is on your list of readings for Seminar 1, and we will talk about it then. MacDonagh puts forward a hypothesis about the development of the administrative state in Britain. In fact, the article has spawned a critical literature which challenges its ability accurately to account for developments in the UK. And we might suppose, therefore, that it would be still less germane to Canada. But it is a touchstone of historical scholarship. And I think that even if we might question some of the details, it still has some important insights to offer us. Anyway, MacDonagh outlines a stages model of government growth. In other words, he sets out a sequential pattern according to which he thinks government developed in the 19th century. In fact, he has a book called A Pattern of Government Growth, and the title perhaps better captures the core idea of his scholarship. And the hypothesis he puts forward is that the modern approach to government developed not all at once, but sector by sector, but that when it did occur, it tended to happen according to a common pattern that can be represented in a 5-stage model. The first stage of the model begins with what MacDonagh calls the exposure of a social evil. Perhaps this would be the result of a dramatic event like an explosion in a mine or a railway calamity. Or it might be a more gradual awareness of some abuse like excessive pricing or poor housing conditions. This would cause public pressure that government should do something. This pressure was usually resisted by the relevant commercial interests for as long as they could do so effectively. But eventually they gave way, not completely of course, and legislation is passed, usually based around a compromise with the industry, and usually therefore without adequate remedies in place. But legislation was passed. And that created a precedent for government intervention in the sector in future. The second stage comes with the realisation that the original legislation was ineffective. And its ineffectiveness was partly because industry influenced the content of the legislation, as I already mentioned. But it was also because legislators didn't have a good understanding of the problems they were dealing with. The operation of mines or railways, for example, or the root causes of social unrest. And it was also because the original legislation didn't give adequate attention to issues of implementation and enforcement. Providing people with legally enforceable rights, it turns out, does not stop a factory boiler from exploding, nor does it keep an overladen ship afloat. And so pressure would build for legislation that more effectively dealt with these problems, by establishing special enforcement procedures and an inspectorate to ensure that the law was actually complied with. This, for MacDonagh, is a huge step because it means that there is for the first time regulation in a sector and a body of officials dedicated to solving the particular problem with which the regulation is concerned. In the first place, it created the conditions in which the full extent of problems could become known. Factories could be inspected, the scientific causes of the blight of agricultural land around chemical plants could be examined, the living conditions of urban working classes could be documented, and so on. But equally important was the fact that once a cadre of permanent officials had been established for the management of a particular problem, these officials' perceptions of the problem and the shape of any solutions becomes a primary influence in the subsequent development of law and policy. And this in turn changes the character of further reforms of the sector. At first, administrators see the problems they are dealing with in fairly simple and static terms, solvable by new legislation, more inspectors, and above all by a greater degree of centralisation of oversight. This marks the third stage of government growth. The fourth stage in the model comes when the attitudes of officials as well as the industry begins to change as they acquire experience of regulation. Over time, industry devises strategies to evade regulation. They practice what McBarnett and Whelan come to call creative compliance. That is, complying with the strict letter of the law, but in a way that does not engage with or even actively undermines the broader purpose of the law. MacDonagh describes a subtle transformation in administrative outlook. Whereas officials might have seen a problem as solvable by a one-off measure, such as increasing the number of inspectors or reforming the legislation one more time, they come to see improvements as a slow, uncertain process of closing loopholes and tightening the screw ring by ring in the light of continuing experience and experiment. This leads to a fifth stage in which administrators started to demand legislation which gave them broad discretion, not merely as to enforcement action, but in framing the regulations themselves. And they start to use this discretion in a quasi-scientific way. Their studies of social problems or of the scientific and technical aspects related to their work become more systematic, and they make a conscientious effort to base their regulatory measures on the best scientific advice. This, finally, is the administrative state in the sense that is familiar to us. As MacDonagh puts it, in the course of these latest pressures towards autonomy and delegated legislation, towards fluidity and experimentation in regulations, towards a division and specialisation of administrative labour, and towards a dynamic role for government in society, a new sort of state was being born. Now, as I indicated at the start of this lecture, this is of course a generalisation, and it doesn't accurately account for the way government regulation developed even in the UK, but I think it does capture something of a dynamic that is in play both in the UK and in Canada. Take as an example the development of railroad legislation in Canada. Legislation in 1851, this is still the pre-Confederation era, sought to balance the perceived need for the state to underwrite the expansion of infrastructure to the frontiers, as well as to limit the price gouging efforts by railway companies. It attempted to do so by imposing a 6% rate of return on railway investment. Just how this worked is a bit beyond the scope of this module, but if you're interested, Google Averse-Johnson effect, or ask me in the seminar. Anyway, the Railway Act 1851 led to the establishment of the Railway Committee of the Privy Council, which was composed of cabinet ministers. But its work was not regarded as very effective. And by the 1870s, pressure was mounting for change. Canada was in recession and farmers and merchants blamed the railways for charging excessive or discriminatory rates. And they blamed the government for its ineffectiveness in dealing with the problem. Railway Committee members were, as the Galt Royal Commission report of 1888 later recognised, part-time, Ottawa-based, lacking in expertise and vulnerable to political pressure. Pressure mounted for the establishment of an independent body modelled on the British Railway and Canal Commission. And although this was rejected by the Galt Commission, pressure for regulation by independent commission was mounting. Sir Wilfrid Laurier appointed what one of the textbooks calls a one-man committee of inquiry, S.J. Maclean, to legitimise the notion of an independent railway board. And in a year after Maclean reported, the Railway Act 1903 established a board of railway commissioners. Oversight of railway regulation thus passed from a part-time amateur and political body to a professional body of administrative professionals. The board was tasked with overseeing Canada's railway legislation, including, most importantly, the Crow's Nest Pass Agreement of 1897, which agreed a reduction in the rates on the eastern shipment of freight from the prairies, but had other implications for the structure of the pricing of railway services. Before the First World War, it accomplishes this role by acting as a dispute resolution body, hearing complaints of discrimination from shippers, but it was easily overwhelmed by submissions from the railway companies, who would respond to complaints by drowning commissioners in technical data. The board, for its part, would tend to split the difference between what the shippers were demanding and what the railway companies claimed was appropriate. Not, you might think, the most scientific way to deal with complex economic issues. But over the course of the First World War, the board increased its influence, although it struggled to set rates effectively in an environment of over 100% inflation. But it persevered in its task through the war and the Great Depression, and in fact the crow's nest rates were re-established in 1924 and remained in force until the 1980s, if you can believe it. So in spite of its ongoing struggle to evaluate arguments put before it, and despite the challenging task environment, the Board of Railway Commissioners has been an enduring feature of the administrative state in Canada. And although the development of railway regulation does not exactly fit MacDonagh's model, it draws attention to some key features of regulatory development, including the gradual build-up of pressure for change, the perceived need for specialist professional expertise to provide effective regulation of the sector, and the influence that these experts have on the subsequent reform of legislation. I should say that there is no need to dig more deeply into the highways and byways of railway regulation in Canada, fascinating though that is. I just wanted to give a concrete example of the development of the administrative state in Canada, and I used to enjoy researching infrastructure regulation. In fact, I wrote a few articles on Jamaican electricity and telecommunications regulation with my colleague Martin Lodge. But if you are interested, I took most of the information on which I based this example from a book by Ken Cruikshank called Close Ties, Railways, Government and the Board of Railway Commissioners, 1851 to 1933. Now what, following MacDonagh, I call the growth of dynamic administration, created a number of constitutional dilemmas. I have already hinted about how controversial the idea was that policy should be made by an independent body. In fact, it was seen by many at the time as inconsistent with the Canadian system of responsible government, and it ran contrary to the firmly held belief that the correct body for the redress of social grievances was the legislature, either the Canadian Parliament or the provincial legislatures, as the case may be. It also ran counter to the idea that the courts of common law were the appropriate fora within which to resolve disputes about the application of the law. And it was not clear how other institutions should respond to this growth of dynamic administration, often undertaken by independent bodies exercising broad discretionary powers. One approach with which Canadian lawyers of the time would have been familiar through their knowledge of English administrative law would have been to challenge administrative decisions on the basis of the ultra vires principle. And sure enough, administrative decisions were challenged on this basis, with the courts often taking a restrictive interpretation of federal statutes. For example, in British Columbia Electricity Railway versus Canadian National Railway, the Board of Railway Commissioners was held to have the power to regulate only railways established by federal legislation and not, as in this case, a foreign-owned BC rail operator. But in the context of the Canadian Constitution, and especially given what it provides for in terms of federalism, challenges were also grounded in an alleged conflict with the Constitution Act 1867. In fact, much of the New Deal legislation of Prime Minister Bennett was overturned by the courts. At the time, there was still an appeal to the Judicial Committee of the Privy Council, essentially the British House of Lords sitting as a court of empire and dominions, and almost all of Canada's New Deal legislation came before it. All but one of the decisions of the Privy Council were given by Lord Atkin. You may remember Lord Atkin from the snail in the bottle case, Donoghue and Stevenson. J.A.G. Griffith describes him as a brilliant law lord, though I wonder how many Canadians would agree with Griffith on that, because his decisions show what I would understand to be a complete misunderstanding of the nature of Canadian federalism. Perhaps you disagree with me, in which case let me know. Take as an example the ILO case. I understand you have covered this in Canadian constitutional law. The case concerned labour legislation passed by the Federal Parliament of Canada, implementing obligations that Canada had signed up to as a consequence of its membership of the International Labour Organization. Section 132 of the Constitution Act gave the Parliament and Government of Canada all powers necessary and proper for performing the obligations of Canada, or any province thereof, as part of the British Empire towards foreign countries arising under the treaty between the Empire and such foreign countries. But Section 92 of the Constitution reserved to the provincial legislature certain matters as falling within their exclusive competence, and Lord Atkin found that the subject matter of the 3 ILO statutes touched on matters that fell within the province's exclusive competence. Whenever a treaty involved a provincial matter, Lord Atkin held, cooperation of the provinces was required for the treaty to be implemented. Otherwise, the federal government and Parliament could, by entering into an agreement with another state, extend its legislative competence beyond that contemplated by the Constitution Act. But this overlooked the intent of the framers of the Constitution Act who, undertaking their work in the aftermath of the American Civil War, sought to create a strong Canadian government and Parliament at the central level. But stepping back from the details of these decisions, what I hope that you see is that these approaches, both the use of the ultra vires principle and the approach of constitutional interpretation, failed to solve the problem. The administrative state and the dynamic approach to administration which accompanied it was here to stay because the public demanded action from government, and the traditional lawyerly approach of autonomous law could not deliver what the public wanted. So the responses of the courts, though different between the UK and Canada, were a reaction to that conundrum. English administrative law went through what Schwartz and Wade call a period of debility. Lord Justice Sedley speaks more colourfully of the long sleep of administrative law. In Canada, on the other hand, the response was for the courts to dig their heels in and set their face against the rise of the administrative state. And of course, neither approach, neither that of the English courts nor the Canadian courts, was satisfactory. What was needed was an approach that subjected this new sort of state to some form of external control. Individuals should not be left to the tender mercies of bureaucracy. But nor was the administrative state an evil, not even a necessary one. It was a new way of governing, and its powers had to be exercised conscientiously. And the role of law in ensuring that it was still being worked out. This, as I discuss in the conclusions to my book, that you will read in Seminar 2, is just what the Quartet did. This, as I discuss in the conclusions of my book, which you will read for Seminar 2, is exactly what the Quartet sought to do. The other video for this week is all about the Quartet, the 4 leading cases of English law which revitalised administrative law in the 1960s. So if you don't know what I mean by the Quartet when you're watching this, you need to pause and watch that video and then come back. Anyway, as we argue in our conclusions, all 4 decisions of the Quartet are, in different ways, about the House of Lords facing up to the challenges of dynamic administration, starting to fashion new ways of providing legal oversight to the administrative state, but in a way that presupposed the legitimacy of this new way of governing, provided it was subject to appropriate judicial supervision. And in Canada too, jurists started to search for new approaches to administration. The antithetical attitude of the courts and the formalist style of reasoning that they employed gave way to a functional and pragmatic approach to questions about the relationship between courts, Parliament, Cabinet and delegated decision makers, such as boards and tribunals. Unlike developments in English law, this was not so much a judge-led process, but one in which the judiciary, engaged academics, legislatures, and others were involved. The writings of John Willis were important, for example, in persuading many Canadian lawyers that, given the level of government intervention that the public was demanding, some sort of delegation of powers to tribunals and other administrative agencies was inevitable. The writings of Bora Laskin, a future Chief Justice of Canada, tried to articulate new ways of thinking about the law that were functional and realistic and which would serve the changing needs of modern society. Of particular significance was the McClure Commission, which was set up in 1964 in response to legislative proposals that would have conferred broad-ranging powers on the Ontario Police Commission. The McClure Commission's report led to the enactment of a number of federal procedural statutes, and we'll learn about these in due course. But they included the Alberta Administrative Procedures Act 1966, and in Ontario, the 1971 Statutory Powers Procedure Act. These were, to some extent, modelled on the US Federal Procedure Act 1946, which brings me to another point that will crop up from time to time in the course of this module. And that is that the approach of the Canadian courts has often been influenced by US administrative law decisions, and administrative law scholarship too. But this is true also in the UK, as you will find out when you read my article with T.T. Arvin, The Curious Origins of Judicial Review. So this is the point at which I will end my account of the growth of the administrative state and the legal responses to it. I have taken you from before living memory to the dawn of the modern era. You will look in more detail into the issues I have discussed in your preparation for Seminar 1 in Week 3, and we will pick up the story and how it develops into the contemporary era in later lectures, workshops, and seminars. But for now, I'll say goodbye. Some of you will have me for seminars. For others, I'll see you later in the module when I teach substantive review of administrative action after reading week.